All right, Rick, you ready?
It's ready. 5, 4, 3.
The designated hour having arrived, I call to order this regular meeting of Ansel Glink's Quorum Forum podcast, the podcast Local Governments Need to Do Business. In the chair, it's me, Daniel J. Bolin, and on the agenda today, we're celebrating summertime, talking about sunshine laws, including the latest guidance from the Public Access Counselor, the Open Meetings Act and Freedom of Information Act during the COVID-19 pandemic. And later we'll review how the state of Illinois and large counties are distributing CARES Act coronavirus relief funds to local governments. But first, let's take the roll. First, we have an attorney here at Ansel Glink who writes regularly for Ansel Glink's popular Municipal Minute blog. He washes his hands for at least 20 seconds, and we're going to ask him about it. Eugene Bolotnikoff is here.
Pleasure to be here, Dan.
Eugene, what song do you sing in your head to make sure that you wash your hands for at least 20 seconds?
Ooh, that's a good question. You know, the Bee Gees' Staying Alive comes to mind.
That's a good one. That's important. And I think, you know, it's a real tough time out there for everyone that is trying to just get through this pandemic. I think it would be really helpful to them and to me as well to lift our spirits if you would sing a little bit of that song for us right here on the podcast. Would you do that?
Here it goes. And that's the full extent of my singing.
All right, Rick, we'll need you to clip that and loop it for about 20 seconds. And then you can
Please don't.
out
I never want to hear that again.
For our listeners to make sure that they wash their hands. Thank you for joining us, Eugene. Next, we have a law clerk at Ansel Glink. She's a law student at DePaul. She's getting ready for more remote learning this fall. We're going to ask her about it. Keri-Lyn is here.
Thanks for having me, Dan.
Katie, what is the strangest thing that you've encountered in one of these newfangled online lectures?
The strangest thing actually came from one of my professors. She brought her dog to teach twice a week, every class, and he was dressed up in a different Halloween costume every single class. So definitely something you don't see in normal law school circumstances.
That is true. What was your favorite costume that you saw?
He was Buzz Lightyear from Toy Story. It was very intricate, helmet and all.
Oh, that's incredible. Well, we'll have to see what the fall has in store for you. I'm sure there's more costumes, more businesses starting to pop up. The Spirit Halloween stores are starting to take over. It is August after all.
Yeah, it's about time.
So we're looking forward to that. We're also joined by a bunch of local government folks here today on the stream, ready to share their questions with us. We'll try to get to as many questions as we can today. Feel free to hit us up in the chat and say hello. And as always, we're not giving legal advice. You'll need to talk to your attorney for that. But we are hopeful that the information we share with you today will be helpful general information to help you get through these trying times. But behind the glass and for our protection and on this video stream, not even displaying an avatar of any kind, it's Engineer Rick. Engineer Rick is present. When we have a quorum, now on our agenda, it's summertime. We have to talk about sunshine laws and the latest guidance from the Public Access Counselor, better known as the PAC, in a segment we're calling Packing Heat. Pew, 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 pew. Those are, for the listener, those are great sound effects, Eugene. Thank you for sharing those with us. So, Eugene, in the beginning, there was the Big Bang, and then Ansel Glink started representing local governments, and then the General Assembly adopted the Open Meetings Act, and allowed remote participation rules. And so back in the before times, and still today, remote participation for members of a public body, you've got a physically present quorum, allowing the member to participate remotely under adopted rules, and you got to have a reason. Those classics: the personal illness or disability, employment purposes, or business of the public body, or a family or other emergency. And so that was what local governments have been doing to allow remote participation for many years. And so then came the pandemic. We've talked about it before on this podcast. The recent Open Meetings Act amendments remind us about them that now allow meetings without a physical quorum. What does the new law say?
Well, the new law in legalese, Senate Bill 2135, amended the Open Meetings Act to permit public bodies to be able to meet remotely without a physical present quorum at the meeting location, which is a big development.
Very good. It's that this new authorization to have meetings without a physical quorum under certain conditions.
Yes.
Meetings by web or video conference. What are some of those conditions? Remind us, what are those boxes that you have to check in order to take advantage of these new Open Meetings Act amendments?
Some of those provisions include having members of the public body be verified to be able to hear one another in their discussions. Votes will be conducted via roll call and be recorded with respect to each member's vote on an issue. A new change under the law also permits recording or mandates recording all portions of an open meeting, including the open session, as well as one member of a public body, the chief legal counsel or chief administrative officer has to be physically present at the meeting location unless it's unfeasible.
Right. And so that's during the meeting. But the couple things got to be,
That's right.
I remember correctly,
Yeah.
got to be in place before you get.
Yes, in order to have the remote meeting in the first place, the governor of Illinois in this case has to issue a gubernatorial disaster proclamation for all or part of the public body's jurisdiction. And as well as the head of the public body has to determine that an in-person meeting is not feasible or practical because of the disaster and state the basis for that finding on the agenda or at the meeting itself.
And me personally, I barely remember a time before we weren't living under a public health disaster declaration. But the governor does put new ones out every 30 days. And if you notice the last couple, there's a little love note to local governments at the bottom of them and says, hey, this is how many people it is feasible to be at a meeting location, at a regular meeting location under the recent Open Meetings Act amendments. In the last two declarations, he said that number's 50. But I know of very few local governments that meet in a place that could fit 50 people sitting 6 feet apart. And so if you're going to have physical attendance at meetings, you got to put some extra thought into what's open and convenient. And so the public access counselor, our friend, came out with some guidance early on in the pandemic and recently reminded us about ways to facilitate meetings that are open and convenient. What are some of those strategies that local governments can use?
Well, Dan, I'm glad you brought up the open and convenient requirement. That's one of the seminal requirements under the Open Meetings Act itself. And the public access counselor has issued guidance to the public bodies about facilitating methods for the public to be able to participate in public comment, hear the matters, votes, and deliberations of public body members during public meetings happening remotely. And some of the most sensible ways to do this amidst a pandemic and other foreseeable disasters in the future would be through remote access methods, such as video conferencing, audio, telephone, and other similar methods. whereby the public can still participate in meetings but be more distanced and safe amidst these times.
That's good to know. And any other important reminders from the Public Access Counselor guidance about open meetings you want to share with us?
Ooh, not to come to mind, Dan.
I mean, I think you crushed it personally, but the thing that I want to about that guidance, what did the Public Access Counselor say about our other favorite sunshine law, FOIA, the Freedom of Information Act? What did the Public Access Counselor say about that?
With respect to FOIA, amidst this pandemic, there's still difficulties in people being able to return to work. Offices are either partially or fully closed, and there's a whole host of other issues associated with this pandemic. So you'd be surprised to learn that neither the governor nor the legislature has relaxed the time to respond to a FOIA request, which stands at 5 days. However, public bodies are not adrift in the sea of nowhere. They have some existing mechanisms to help them out during these times, including under the statute as it's currently written. They have 5 days to unilaterally extend the time period to respond, or they can also enter into an agreement with the requester for a reasonable, mutually agreeable time to respond to a FOIA request, which is encouraged during these times when many people are not at work or don't have access to typical file record repositories. An extension can be a tremendous bond to public bodies.
That's important to remember. I think that the General Assembly was considering some FOIA relief during their shortened session, but that did not make it into the final bill. But as you pointed out, we're not without. It's not. We've got existing tools available to manage FOIA requests, request extensions, requests agreed upon extensions, and shoot, you're going to be able to reach out to someone. I would hope they would be more understanding during these trying times. Communicating with the requester is you're more likely going to be able to arrive at that kind of mutually agreeable result. So that's something to do. Don't just ignore the request because of the pandemic, but reach out to them. It's probably a good idea. So that's good guidance from the Public Access Counselor. We'll include a link in the show notes. Anything else about the guidance? But if there's nothing left on that guidance, there's a recent PAC binding opinion that I want to ask you about.
One more thing on the FOIA guidance.
Sure.
Sometimes it may be impractical to obtain an extension with a requester beyond 5 days because they may flatly refuse, even during these circumstances.
Yeah.
So the PAC also encourage public bodies to use the unduly burdensome exemption, which can particularly apply if there are voluminous, large amounts of records that a public body has to review and the office is closed, for example, or they have to go to an offsite location to be able to review these records. Making use of that exemption can certainly be beneficial. Another tool there, though I wouldn't want to just be while it's a unduly burdensome time, FOIA requests aren't by definition unduly burdensome during this pandemic. You'll probably have to find some facts like the ones you just mentioned. They're stored in other location. The office is closed to help sustain that claim. And you've, of course, got to communicate that claim to the requester. Good guidance. We'll let folks take a closer look at that in the show notes. But the PAC did have a binding opinion. I'm just chomping at the bit, champing at the bit to hear about it. What was this binding opinion about, and what did the Public Access Counselor have to say? So in this case, the PAC denied the ability of a public body, in this case, a law enforcement entity, a sheriff's office, to deny certain records regarding a fatal car crash using one of the law enforcement exemptions listed in FOIA. Oh,
that's sad. But what the car crash, but FOIA is interesting, and we've got to hear about this how this exemption was applied. What did the public access counselor have to say?
So specifically, the public body in this case tried to use a FOIA exemption by the name of 71B3. That's a mouthful. In layman's terms, that exemption is used by public bodies to withhold records that would create a substantial likelihood, or more likely than not, of interfering with a fair trial or an impartial hearing. In this case, the public body tried to use that exemption to claim that they could withhold the records because it would impede the ability of members of the sheriff's office to have a fair trial in a pending wrongful death litigation if they were to disclose these records.
Yeah, so the argument is, if this requester, a reporter, I think in this case, right, and got a hold of this this crash video and these other records, they'd be in the media, and we could never have a fair trial because how would we pick a jury if everybody saw this video? And so, what did the public access counselor say after taking a look at this video?
After taking a look at the records and the arguments made by the public body in this case, they denied the use of the exemption because the public body failed to specify how and why disclosing the video and other records would interfere with a impartial trial or fair hearing. Likewise, like you mentioned with the reporter requesting this, the sheriff's office repeatedly made the claim throughout the PAC opinion about the negative impact of publicizing the video and related records upon the ability to select a jury, an impartial jury, during the trial forthcoming. However, even that assertion was largely speculative and conclusory, and the public body never was able to prove by clear and convincing evidence how disclosing these records would interfere with a fair trial or impartial hearing. So the PAC ultimately ruled against them on that ground.
I mean, this is you see this in PAC opinions all the time. It's not enough to just recite the exemption. You got to say some facts that support it. And if the specific to these records, I guess I read this opinion and it talked about the video. The video was taken from far away, and so it wasn't this. While it was of a tragic car accident, it was unlikely to be so prejudicial to taint a jury like a close-up video might have, right?
Exactly.
It's you hear this all the time. Don't just recite the exemption. You got to beef it up with some facts specific to the records at hand. If they found the other way, I guess every car crash video would be exempt, right?
That's what they're afraid of. The PAC repeatedly harps on this term, detailed factual and legal basis. They want to see that from public bodies trying to use exemptions. Yeah,
I've heard that before, and I know you have that that tattoo that says that.
Right.
But anyway, for the listeners at home, Eugene is showing us in the stream his tattoo, and it's a very nice one. But anything else from the binding opinion before there's that FOIA case I know you wanted to talk about?
Nothing more that comes to mind about the binding PAC opinion, Dan.
So Chicago Police Department recently prevailed in a FOIA case involving a diligent search for records, and every time that local governments get or FOIA officers get a request, they perform these reasonably diligent searches. So it's helpful to hear about when courts talk about what that means. So tell us about this case.
About this case, prior to discussing it, I figured I'd give a little background about reasonably diligent searches themselves.
Oh,
if
please.
We think about a FOIA timeline, I think of three basic steps. The first being receipt of the FOIA request and identifying what records the public body may need to produce. The third step being either producing the records entirely, producing part, denying a part, or denying them entirely using existing exemptions. The intermediate step, the reasonably diligent search, is a very important step, but not often thought about or contemplated seriously. This case took the opportunity to discuss what a reasonable diligence search entails in slightly more detail. Specifically, a public body's reasonably diligent search is not judged on the fruits of the search per se, meaning what records they produce, but whether the search itself is adequate. And adequacy itself is judged by whether the search is reasonable. Now, that's an ambiguous term, and it can mean various things depending on the particular FOIA request or the public body. But generally, the PAC has said before, as well as Illinois cases, that looking at physical and electronic records for identifying particular records responsive to a request, as well as consulting with records custodians at your public body who are best equipped or most knowledgeable to find the records, is a good indicator of conducting a reasonably diligent search. So in this case, CPD received a request for investigative and homicide records. The FOIA officer forwarded the response to CPD's Bureau of Detectives, who produced an affidavit during this case that detailed them looking at all the requisite physical and electronic locations, giving it to personnel in the Bureau who are particularly apprised of where investigative records might be. Consequently, the judge in this case determined that CPD's reasonably detailed affidavit highlighted that they conducted a reasonably diligent search, and the requester's speculative claims about records that may or may not exist was not sufficient to rebut the diligent search the public body highlighted.
And I think that's one thing that the court suggested in the case, if I remember, is that they were successful and proved it up with this affidavit, but gee whiz, the local government, the police department in this case, could have explained what they did in their FOIA response in terms of a reasonably diligent search, and explain how, look, believe us, we looked. Like these are all the things that we did, and to find these records, and so it's something to think about when you're responding to a request and say like, we didn't find any records. Might be helpful to say a thing or two about what you did to find the records.
You make an excellent point. You don't want to get to the litigation stage and have to explain your reasonably diligent search. You have a bite at the apple when responding to an initial FOIA request, and if necessary, when the PAC issues a request for review. So there are abundant opportunities to develop and perfect detailing those searches.
What else? What other issues came up in this case about this FOIA request? We got the reasonably diligent search. What else did the court? What other arguments were resolved in the case?
The court also addressed the meaty and exciting issues of whether a public body waives FOIA exemptions if they previously provided records to other public bodies, as well as whether a public body is guilty of civil penalties for responding in bad faith to FOIA requests.
Oh, so what happened in the case, and why did the plaintiff, I guess the requester, think that the police department waived this argument, or waived the release of these records?
Right. The plaintiff requester argued that CPD formally provided the investigatory records at issue to a state's attorney's office in response to criminal discovery. And his contention was, hey, if you produced these records before without redaction, why am I receiving the records only with redactions? However, the court clarified that the disclosure requirements for criminal discovery and FOIA are markedly different. Specifically, FOIA is not a discovery tool, contrary to what some people think. So just because CPD formally produced these records in response to criminal discovery did not prevent them from using applicable exemptions in this case in response to a FOIA request.
So do local governments have to treat FOIA requests and discovery requests the same? What did the court say anything about that?
Yes, the court said they should be treated differently.
This is good to know. There are different procedures, and there's different things that have to be produced or can be redacted are exempt under FOIA that may or may not be exempt through discovery proceedings. So it's helpful guidance from the court on that one. Anything else come up in this case?
I think with respect, the requester argued that because he submitted his first FOIA request and received 60 records versus 242 records, if memory serves correct, for the second request, he said that that's clear evidence that CPD responded in bad faith to the second request because, hey, I got 100-something plus records in the second one. The court said not so fast. The 60 records produced for the first request were for a narrower framed request versus the second one being much broader. Therefore, the court reasoned that just because the first request is more narrow is not evidence that CPD had bad faith or willfully or intentionally refused to produce some records. So they denied the imposition of civil penalties on CPD in this case.
Well, it looks like the CPD was prevailed in this case, and had some helpful guidance from the court about reasonably diligent searches or others. Or you have any final thoughts about sunshine laws you want to share with us from about any of the cases you talked today? You want to cite your favorite FOIA exemption or Open Meetings Act exemption, or share your favorite summer plans other than reviewing sunshine laws, walking through the park at a safe social distance.
I'll tackle one last thought first, and then my summer plans. With respect to the PAC's guidance on FOIA and the OMA, I neglected to indicate that the PAC advised public bodies, but this is not a legal requirement, that public bodies should permit requesters to submit public comment by email. That could be quite onerous for public bodies, so it's not required, but it's worth noting. Regarding summer plans, as some of the people, listeners may know, I had a wedding recently scheduled that was canceled due to COVID, but nonetheless, me and my fiance got married last week, so I'm very happy about that.
Whoa, this is way big news, almost as big as this public access counselor guidance. It's 1 and 1A in my book. That's incredible. I did not know that, Eugene. We should have let off the podcast with that. I wouldn't have made you sing. But that's incredible. Congratulations.
Thank you, Dan.
I hope you have a very happy summer, happy marriage. That's a difficult time with lots of family and friends celebrating weddings in unusual circumstances, and glad that you're among them. But it's going to be a good time. I hope your bride enjoys hearing about public access counselor guidance as much as I do. And to put a pin in that point, public comment rules, and that find time for local governments to review their public comment rules to accommodate these new avenues of public participation you might not have allowed in the past, and to manage all those emails that are coming in, but allowing these other redundant avenues of public comment through whether it be by phone conference or video conference or by email, having rules to manage that, but still facilitate that open and convenient public meeting during challenging times is a good thing for local governments to do. But most importantly, in all seriousness, Eugene, congratulations. That's outstanding. And but we do have to move on with our agenda. Please stick around and share your thoughts with us on our next topic. It's time for Coronavirus Relief Fund with Coronavirus Relief Funds. Keri-Lyn is here. Katie, the CARES Act, you'll remember in the early days of the pandemic, the appropriated coronavirus relief funds to state and local governments. and they are finally making their way to be distributed to from the state and to other direct recipients to local governments. How has the federal government dispersed CARES Act funds to Illinois?
Slowly but surely, the federal government dispersed CARES Act funds in two different ways. So first, they've given direct disbursements to each of the 5 most populated counties in Illinois. So that's Cook, DuPage, Kane, Lake, and Will. And then the remaining counties receive federal funding through Local Cure, which is the state of Illinois mechanism to distribute the CARES Act funding to local governments.
So you've got the feds, they give coronavirus relief funds to the direct recipients. You've got the state, and then those big counties, and so the state, the General Assembly had to pass a law to create this local cure program that's being run by DCEO. They've got lots of great guidance, and we'll include links in our show notes. But what is DCEO telling us how it's distributing funds to these local governments outside of those large counties?
So every single other county, like you said, it's run through DCEO, and they also hired on a consultant with Crow LLP. So they're helping facilitate that process. And they determined some not to exceed values based on populations of each county in Illinois, under which local governments are allowed to claim that reimbursement. All of those delegated amounts are on the DCEO Local Cure website, which is, like you said, an awesome resource. They answer a lot of questions and keep it updated very regularly. But they automatically allotted funds to municipalities, counties, and public health departments. So no application required. They figured out the amounts, and the only thing that those groups have to do is submit contact information to receive a grant agreement. So all they have to do, go on the DCEO website, fill out the form, and then they're good to go. I mean, there's obviously other steps, but no application process needed.
Oh, that's good. Well, for some local governments, other local governments had to apply, right?
Yeah, they did, but that's closed now. So this round of funding, it's up to municipalities, counties, and public health departments.
Got it. So they'll get a grant agreement, and there's lots of technical assistance webinars that are happening. What is DCEO saying is eligible for reimbursement and what's not eligible for reimbursement? A lot of this will apply to all these funds, right?
Correct.
Because they're dictated by the federal guidelines. But
Correct.
what's DCEO say about what's reimbursable and what's not?
So DCEO looked at the U.S. Department of Treasury guidance and made a test for us. Thankfully, thank you, DCEO. So they said that each expense, in order to be considered reimbursable, has to be connected to the COVID-19 public health emergency. It must be considered necessary. It cannot fill a shortfall in government revenues. It cannot be funded through another budget line item, allotment, or allocation as of March 27, 2020, which is when the CARES Act passed and was enacted. The expense can't be reimbursed through a different emergency response program, and it must not have existed without COVID-19 or would be used for a substantially different purpose.
That's a handy 6-part test, and you'll. I feel like we're getting questions from clients and running their questions through the 6-part test.
Yeah, it's very helpful.
Yeah, so this is super helpful for for questions that folks in the chat or in the stream or listening at home might have. Is this reimbursable or not? So that's the test. How do they actually go about getting funding?
Yeah, what everyone actually cares about, right? So no applications required, like I said previously, for municipalities, counties, and public health departments. Everything's electronic. It's run through a portal that Crow LLP is establishing with the DCEO. So the first step in this process, in early August, the DCEO is going to be sending out certifications to the contact person who entered their information on the website, very helpful website, for each unit of local government to fill out. The certifications serve the purpose of notifying each local government of its not to exceed allotment, and they also ensure that each local government understands its obligations and requirements in spending the local cure funds. So the contact person, once they receive the certification pretty soon here, should review, sign, scan, and return the certification by October 1. In the meantime, they can go ahead and start collecting documentation for all of these expenditures. Crow and the DCEO are going to have a webinar on August 12th, where they're going to announce their standards for this documentation. So that's a big day, because they're also going to be releasing a manual on August 12th to help provide more guidance through this process.
Now, this webinar, I've been circling on my calendar for a long time, but I feel like that's as of this recording. The local cure website is being updated all the time. Dates are a little mushy and kind of moving around.
Changes every day.
So while we hope August 12th will be the big day, and it won't nearly be as big as Eugene's recent big day, but but close. It's probably going to be a good webinar. but check the local cure website for the latest information. Am I right?
Absolutely. Always check the website.
What else do we need to know about things that local governments can do to prepare for this local cure program?
Yeah, digitize everything. Digitize your bills, digitize your invoices, digitize your receipts, get them scanned and organized. So the DCEO gave us 7 different categories that they have to submit the documentation under. So we're helping them out. They've helped us out a lot. It's the least we can do. Organize the expenses into those 7 categories. So first one is payroll for public health and safety employees. Next is personnel and services diverted to a substantially different use. Then improvement to telework capabilities of public employees, medical expenses, public health expenses, distance learning, and then everything else. A big catch-all that the DCEO asks to also subgroup the everything else category.
Right, because there might be things that are still eligible under the guidelines that don't meet one of those categories. But that's an important reminder. Local governments will need to be prepared to explain how these expenses are connected to the pandemic and meet all those standards. So what is the timeline look like for the rollout of this program as of this recording?
As of August 3rd at 5:38 p.m. So the DCEO is going to start sending out those certifications to the contact person of units of local government starting today. So those should be rolling out pretty soon. August 12th, again, is the big day, the technical assistance webinar and the manual release date. So that's an important one to tune into. And then on November 1, the DCEO requests that local governments provide a status report. That should include any unspent allotments, any plans for those, and then any additional expenses that local governments have in excess of their original allotment. That report's due by December 1, so you have a month to fill it out. And then everything, all the documents, all the receipts are due through the portal by January 31st, 2021.
That's all good information. It's being updated all the time on TCO's website. It's a good one. We'll include a link in the show notes, like we promised. Any final thoughts about local cure before we talk about these big other direct recipient counties that are starting to share with their local governments?
Yeah, so one last thought on local cure. I would just like to say keep in tabs with federal legislation, because right now governmental revenue shortfall is not considered an eligible reimbursable expense, but that could change with the Federal HEALS Act, which is going through the steps right now. So just keep tabs on that, and go to the DCEO website, because I'm sure they'll tell you if it changes as well.
That's true, and that if something changed in Washington, that'll affect all these programs in terms of the CARES Act. Of course, famously, the coronavirus relief funds could not be used for revenue shortfalls, but the one thing that's being considered in both the HEROES Act that the U.S. House passed and in the HEALS Act that's being discussed in the U.S. Senate is making those coronavirus relief funds able to be used for revenue shortfalls under certain conditions, but that seems to be changing every day, and I've been waiting for months for movement on this, and I'm kind of at the point like wake me up when something passes both houses. But like but I mean it's something to be mindful of, that the law might change and be helpful. The biggest difference between the House and Senate proposals at the moment is the House HEROES Act would also include more money for local governments. The HEALS Act really wouldn't. And just both CARES and HEROES and HEALS are all acronyms for what the law is, and I wonder if they pass anything in DC anymore without a snappy little acronym. I feel like the Patriot Act, right? Who's going to vote against that? I think that's the original, real trendsetter. I'm sure there's others, but hey, I promised that we would talk about those direct recipient counties, so let's do it. Cook County has a fairly helpful website with guidance available. Why don't you tell us about how Cook is distributing their funds to local governments?
Yeah, absolutely. So Cook County allocated $51 million of their total CARES Act funding to its suburban municipalities. Everything you need, everything, the application, the required IGA, the guidance, FAQs, it's all online on their CARES Act information for local government's website. As of early August, additionally, each municipality has to submit a resolution or an ordinance along with their IGA that shows that the governing body of the municipality approved it. But that, again, that's a sample. One of those is also found on the Cook County website.
Another website that's being updated all the time. Encourage folks to check on it regularly. If you're a Cook County municipality, which for purposes of their program, you're a municipality. If you're a municipality a township or a fire protection district are all potential recipients under this one, and they're holding they're holding weekly webinars on this for folks that need help putting these applications together. So I encourage folks to check that out. What else do folks need to know about the Cook County program?
So Cook County, like the rest of them, you can submit any your expenditures through December 30th, 2020. But Cook County does require that you inform them by September 30th whether or not you intend to use all of your allocated funding. So if you don't provide Cook County with a plan or an application prior to September 30th, they will rescind their remaining allocation.
Yeah, they had a fascinating allocation procedure. There's even a white paper on their website about how they did this like advanced formula to not only split it up by population, but like public health data and equity data and like all. And they really put a lot of thought about how they are allocating the funds. But just because it's allocated, you still have to substantiate your reimbursement requests and put in for it. And if you're not going to use it, the county doesn't want to lose it to the feds. So it sounds like there's a mechanism to reallocate later on in the program. Anything else for Cook County? We've got a bunch of other counties to hit.
That's it for Cook County. Besides, keep refreshing the website.
We'll keep that website in the show notes. What's going on in Lake County?
So Lake County received $121.5 million total in CARES Act appropriations, or in CARES Act funding, but they're using emergency appropriations to delegate that funding to local governments. So that first emergency appropriation round was at the very beginning of July and gave $9 million to municipalities, then another $1 million to fire protection districts. And then that second round of emergency appropriations was pretty recently on July 27th and gave an additional $15 million to municipalities and fire protection districts, and then another $10 million to other taxing bodies.
That's good to know. What do their reimbursement requests require? What do they need to get the money?
So they need to include a completed IGA, a spreadsheet with a summary of their requested reimbursements, a description of how the expenses related to COVID-19 response and recovery, and then supporting documentation.
Very good. What's going on in, if there's nothing else in the lake, what's going on in DuPage?
Yeah, so DuPage is giving local governments $43 million. There's specific funding numbers for each municipality that are on the DuPage County website. So again, another website that I encourage everyone listening to go look at, refresh, stay updated, because the numbers change all the time.
Rick, you getting all these websites? You got to put them in the notes.
We'll have to listen back after this, huh?
Yep. Expect an email, Rick.
In order to receive all the funds for DuPage County, mayors have to submit their IGA, again, a list of expenses for reimbursement, again, and a certification attesting to those items, all via email. Again, everything's electronic, trying to streamline this process as much as possible. And every applicant will be informed of items that aren't approved, and then will be permitted to then submit alternative requests to DuPage County.
Very good. And I know they're working on. I'm seeing the IGAs for DuPage. They've got the municipal ones. I know the park district ones are working on, and other units of local government too, townships, I think. So that's more to come from DuPage County on their coronavirus relief funding program. But what about Will County?
So Will County, unfortunately for us, has yet to send out an application and make it public. They have a great website, they have great FAQs, they have a great, here's how to prepare before the application, but the application is not yet available to the public. However, you are able to put your email address in, so you can be one of the first to know when this exclusive application drops. So I would suggest going on the Will County website and putting your email in there.
It's like they're putting together a street team for an album drop. They're really hustling to get this buzz going for this application forms. Probably an intergovernmental agreement to come. More information for the Wills program is forthcoming, and then Kane County we need to talk about too.
Yeah, so Kane County is in a similar situation where a application has not yet been made public. In part, that's due to population discrepancy issues. The county board's going back and forth to see if they're going to use census data from 2010 or 2019. Then also they're evaluating competing interests. So we hope that application will also be released soon. I'm hopeful. It seems like they've got something solidified, but just haven't shown it to us yet.
They're big programs, and they've it took months and months to get to where we are today with some of the local cure and the other programs. So counties are working on it. Stay tuned, and we'll be sure to share these websites and the latest information when it's available. Any final thoughts on coronavirus relief funds before we move on with our agenda?
Nothing besides keep refreshing those websites, because I can't stress it enough. There's new information constantly, so it's important to stay in the loop on those.
Yeah, it's fast moving. So thank you for sharing that information with us. But it is a regular meeting. We do have to have public comment. So let's take a look at some questions. Eugene, this one might be for you. Did the General Assembly adopt yet another requirement for local governments to post information on our website?
Oh, thanks for asking, Dan. The General Assembly, of course they did. They recently passed a new law regarding the Illinois Municipal Retirement Fund, the IMRF for short, to post on their website information about participating municipalities contributing to the fund. This information can include, but is not limited to, future contributions and past contributions. The law further mandates that by January 1st, 2021, participating governments that have a website must provide a link on their website to the IMRF Employer Cost and Participating Information webpage. More information about this can be found in our show notes after the podcast.
More links, Rick, get ready. Moving on to the Department of Public Works. Do y'all have any upcoming webinars, articles? Eugene, I know you're writing a Municipal Minute all the time. Katie, I know you've got a couple of recent posts at the Workplace Report. What do you write about over there?
I've been slowly working my way through labor law. Right now, nothing on deck for this week, but expect to post. I just haven't drafted it yet.
What you recently write about over there? I think there were some good ones.
Yeah, I've written a lot about if employers have a right to know about what travel and if they can test employees and everything COVID related, pretty much. I'm learning a lot really quick.
The labor law implications, labor and employment issues with COVID are potentially endless. But we'll do our best to keep up with them. ILCMA is having a webinar on August 20th at 11:30 a.m. Local responses to recreational cannabis with Kimberly Richardson from the city of Evanston, Tim Denton, Chief of Police, the Village of Worth, and Dan Bolin from Ansel Glenk. I know him, and that's going to be an outstanding webinar. If you remember before the pandemic, people are all worried and doing stuff in response to cannabis, and that was that's something that's still happening. Some delays on those social equity applications, but they on those state licenses, but important issues from cannabis still out there for local governments. So before we go, I want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Email us your questions and show ideas at podcast@answellink.com and visit us online at quorumforum.answellink.com. Guys, it was a pleasure having you. Katie, Eugene, congratulations. Rick, do you have any marriage advice for Eugene?
Not for me.
We'll follow up offline.
No comment.
Congratulations. Can I get a motion to adjourn?
Motion.
Yeah. Second.
All in favor?
It never fails, Dad. It never fails.
We'll see you next time at Ansel Link's Quorum Forum podcast. Bye. Thanks, guys.